May I have lordship leave to mention original side and appeal, my lord. Two appeals have been filed. Let it appear on 11th because Parsi Padiola will appear for the appeal in my lord on 11th. He's not in the list today.
He's coming down or
He will be coming, my lord, not on virtual. Deeply applies, my lord.
Yes,
My lord, may I be permitted to mention one mandamus appeal? My lord, it is a very unfortunate case before your lordship. My lord, old and aged my lord father approached before this honorable court. Son and daughter-in-law, they are continuously torturing upon the my lord, parents and trying to oust it. And by an order, your lordship was pleased to direct the district judge to go to set up a mediation. Accordingly, mediator my lord sat twice. My lord, parents appear, but my lord short refused to accept any type of proposal. It fails. Matter is returnable. Kindly fix a date. Otherwise, 86 years old. He is admitted in hospital. Father, very serious condition.
Is it there in the list?
No, Malad. It was returnable. The mediator last passed an order. 20th March 2025. It fails. So, kindly pass an appropriate order. Let it be listed in
the caption to be mentioned. You inform the other side.
I will. Grateful.
Move an appeal without the certified copy.
Date of the order?
25th of March 2025. And my lord, urgent listing. The reason being, my lord, before there used to be with these old people digital arrest, where people were being arrested and money was being siphoned out. This is a new fraud that has now started. The petitioner is 80 years old. He had a power of attorney. He was told to sell the property. So he had given the power of attorney for various people to verify. Now, what the accused person did with the aid of HDFC Bank, they forged his signature, took a loan. Now, when the loan is given, it has to be transferred to a particular account of the petitioner. They created another forged account in RBL, transferred the entire amount. The loan failed, and I have been given a notice now under the Surface Act. So this is a new kind of fraud that has now started with the elderly.
Right. In fact, we decided one matter. We said that issue can be agitated before the debt recovery tribunal.
But the criminal case
that was also a case of fraud.
The criminal case was started, but without going to the case diary.
Leave granted to file, it will be listed.
Very well. Great.
Yes. My lord, may I be permitted to mention for inclusion in the list, mandamus appeal, my lord.
Fresh case?
Yes.
Fresh matter.
Yes.
May I be permitted to mention in regard to item number 134 of the day's list?
What is the urgency?
This is an appeal preferred by the state of West Bengal. My lord, challenging the order passed by the learned single judge wherein the prayer for compulsory appointment to the post of NOMO, non-official marriage officer, was allowed. Since this appeal is pending, taking plea, the order has not yet been complied with.
Contempt petition is pending? No.
No.
You have not filed contempt.
But I mentioned this matter before, my lord. Last 3 occasions, every time my prayer was allowed, mentioning was allowed.
All right, you list it under the caption to be mentioned.
My lord, deeply obliged.
May I have my lordship's kind leave, my lords, to mention item number 1 of the original side, my lords. I am mentioning, my lords, because I'm compelled to do so, my lords, because the matter has to be heard, my lords, within today or tomorrow, my lords. The urgency is such, my lords, that the GEM portal of the appellant, my lords, has been suspended on 28th March, my lords. We preferred a Group 9 writ petition, my lords. The honorable judge, my lords, instead of prima facie finding, in spite of prima facie findings, my lords, has refused to pass any interim orders, my lords. My lords, now my GEM portal has been suspended, has been threatened that all the tenders that I have made a bid on will be cancelled, my lords. My lords, the entire business will come to a standstill, my lords. My lords, will kindly give us some time, my lords, today or tomorrow, my lords.
When is the one? It will come on Tuesday. Wednesday it will come out.
My lords, the bids are starting to be opened from 8th, my lords. That is tomorrow.
How to jump the queue, sir?
Any time, my lords, will kindly give us some time, my lords. 15 minutes will take maximum, my lords. Great difficulty.
That is against the refusal of interim order, you are on appeal.
Yes, my lords.
Refusal or just notice issued, affidavits called for?
It's the affidavits have not been called for. My lords, the interim order has been refused. My lords, the honorable judge, my lords, has relegated us to the respondents themselves, my lords. And my lords, the respondents, my lords, the same authority who has passed the order is the same authority who is the appellant, my lords.
Tomorrow we can do it. Tomorrow we'll do it.
Grateful, my lords. I'm so grateful, my lords.
You please.
Yes, my lords. I am mentioning upon notice. I will again give notice.
You notice saying that the matter will be listed tomorrow.
I'm so grateful, my lords.
Yes, sir.
My lord, may I be permitted to mention one matter, my lord?
One second, madam.
Lord, I have filed one appeal, my lord, regarding group 9, my lord. Let it appear.
Listing.
Your Lordship, I am seeking your intervention in person. My matter has been with Kaushik Chandra's court for last 10 months, and then it went to on determination to Justice Gauranga Kant. I mentioned to him that 4 judicial orders, Your Lordship, your temple of justice, 4 judicial orders have been disobeyed. The respondents in nexus with the police, they have completed the construction. I'm knocking.
And what order was passed?
Your
Your
Lordship,
matter was mentioned, taken up for hearing.
I just now mentioned before Justice Gauranga Kant.
No.
Then I've come here before you that Your Lordship, for 10 months, I have brought it before Justice Kaushik Chandra. He did not take it serious. When I said 4 judicial orders, if I tell before the judiciary that 4 judicial
And now it's running in the list of the order.
he has not taken it or giving me a hearing on this issue. I seek your intervention because, Your Lordship, when a matter of judicial disobedience is taking place and the judiciary is not taking serious of 4 judicial orders, who do I go to except you?
No, the matter is running in the list. See, we have also got such a big list. So it is not that we don't want to take it up. Sometimes one of the appeals will take 1.5 hours. It takes. So we may push through only 5 matters. The other day it may move, 25 matters will move. So you please wait for your turn.
Your Lordship, if you feel there is urgency, kindly intervene, Your Lordship. If you feel there is urgency, because judicial order have been.
What is your serial number?
There is 85, and during Kaushik Chandra's period it was 100, and for 10 months it was continuing 3 to 4 times I went to Kaushik Chandra.
Probably 85, it will reach this week. But how to do that on the administrative side?
I only seek your intervention, Your Lordship, because judicial orders have been violated, and you are the temple of
For
justice.
your satisfaction, we can receive your letter.
Only your intervention, Your Lordship. Only your intervention.
May I kindly be permitted to mention, my lord, this is the my lord, administration matter regarding my lord Lokhi Jonathan Thakur. One my lord, receiver is there. Subankar Bhattacharya made an application, my lord, December. This person is there, my lord. I am having a my lord paralyzed eldest son. I am having a paralyzed son, my eldest son is paralyzed. In spite of that fact, I am coming daily. He has stopped this my lord, all payments. I am showing this my lord, begging heart of the founder. Begging heart.
Now,
Dekhiye, temple.
no, your matter is, has been listed before some court.
Yes.
Before which court it is listed?
Because court, he is no, it's my lord. That
Justice
officer is
Vishwarup
know it. How many times I have come?
Hospital. Now it is before Honorable Justice Vishwarup Chaudhary. You please mention.
No, my lord, your intervention, my lord. I want your
On the
intervention in
administrative
this
side,
matter.
I can't intervene.
Because deed of trust, clear.
On the merits of the matter, in case the matter is released by the judge, I can assign it to some. You please go and mention tomorrow before the concerned court. Yes, then we will see. Yes, madam.
To whom I will mention?
My lord, may I be permitted to mention one matter, my lord? It is about the MAT 903 of 2024, my lord. The hearing has been concluded on 12th of March 2025, and it was in CAV. And till now, we have not received the orders, my lord, as my patent is going to finish on 2nd of May 2025.
That is
My
the
lord.
patent matter.
Yes, my lord.
Yes, shortly it will be delivered.
My lord. My lord. My lord.
Appellate side, monthly list. Serial number 1.
Well, I am for the appellant, my lord. My lord, this is the affidavit of service. And my lord, notice of mentioning is also served upon them, my lord. The petitioner appellant before your lordship is the Rural Bank, my lord, Paschim Bongo Gramin Bank. The respondent before your lordship is a branch manager of that bank, my lord. In 2012, my lord, that branch manager took a education loan from the bank for her daughter, where he is a co-borrower. In 2014, my lord, the petitioner, the respondent appellant branch manager retired from the post. The said loan became NPA, my lord, in 2017. And 2017, and there was in the preliminary, there was no pension scheme in the rural bank. In 2018, after the intervention of the apex court, from 2018 April, my lord, the pension scheme started. Bank issued several legal notice to the borrower, co-borrower, and the borrower for my lord to for the recovery of the loan.
Education loan was sanctioned.
Education loan
All
sanctioned.
right. What was the security given? There is no security.
No security. Co-borrower is the bank manager is itself co-borrower. Bank manager is still go. So my lord, petition.
No, he is now getting pension. If you recover it from pension, what will happen? How will he survive?
No, my lord, not the amount is 3,40,000. He authorizes us. We are sending letter. He authorizes us to recover that amount from our account. It is not we giving any penal provision. It is not any disciplinary provision. Nothing, my lord. It is 3,40,000. My lord, continuous letter from page number 117 onwards. It is his, my lord, authorization given to the bank. My lord, if my lord comes to the
No.
139.
You can't touch his pension account. You initiate action under either Surface Act or you go before the Debt Recovery Tribunal for recovery of the education.
Recovery of the loan. But my lord, page 139 once, my lord.
He gave an undertaking.
Yes, my lord. Several occasions he is giving authorization.
That undertaking he is been compelled to give.
No, my lord.
The learned judge says.
From 2018, my lord, we are not giving any pressure to the petitioner. To the petitioner, he is saying that I am getting the pension, I am the officer of the bank, I pay the money. So, my lord, it is instigation, my lord, bank taking this. Page 139, my lord.
ETC.
And my lord, the judgment is given in the judgment. There was decretal amount section 60 of the CPC, my lord. I checked out, my lord. But this is not that, my lord. This is it is his pen. We are, as per the authorization of the petitioner respondent herein, my lord, he is giving the authorization. My lord, if last 3 years later, my lord, if my lord going from the page 122, there is a 3 years later of the petitioner respondent hearing. From the last 3 years, he is saying that kindly deduct from it, will kindly wait for some time, you will deduct from my pension account. And he is not coming on that. He is happy with that. When bank taking the unapplied interest, my lord, at that moment, my lord, he is coming before this honorable court.
Section 60, Proviso, Clause G. Stipends and gratuities allowed to pensioners of the government or of local authority of any other employer or payable out of any service family pension fund notified in the official gazette, etc., in this behalf and political pension.
Well, I have read that. But here, we are not initiate any punishment. We are not taking any decretal amount. Here, my lord, the authorization given by the
file a suit or what? See, can you issue a 13-2 notice under Surface?
No, my lord, we have to only remedy before the money suit.
Money suit.
Otherwise, my lord,
or you can go before the Debt Recovery Tribunal and the RDBB Act.
My lord.
That's the remedy. This intra-court appeal by the Paschim Banga Gramin Bank. is directed against the order dated April 22, 2024 in WPA 2069 of 2024. The writ petitioner is an employee of the appellant bank and superannuated on November 30, 2014. Though initially he was not paid pension, but subsequently, after a judgment of the Honorable Supreme Court, a scheme was formulated for grant of pension to the employees of the bank, and in terms of the said scheme, pension was disbursed to the bank account of the writ petitioner from the month of April 2018. The case of the appellant bank is that the writ petitioner agreed that the arrears amount of pension payable, sorry, you direct that. The writ petitioner's case is that he had agreed that the arrear amounts of pension payable from October 2014 till March 2018 can be used for the purpose of deducting the outstanding dues on account of the education loan taken by the writ petitioner for his daughter, who was a co-borrower. The petitioner further contended that misusing the said concession, the appellant bank has been deducting alleged outstanding dues every month from current deposits in the pension account of the writ petitioner, thereby depriving the writ petitioner of his entire pensionary benefits. In this regard, the writ petitioner placed reliance on the principle enumerated under Section 60 of the Code of Civil Procedure, and also relied upon the decision of the Honorable Supreme Court in Radheshyam Gupta vs. Punjab National Bank, AIR 2009 SC 930, to support his concession that no deduction could be made by way of attachment for use from the pension account of a person. The case of the appellant bank was that the writ petitioner was agreeable to deduction of the amount from the pension account, and only according to such concession given by the writ petitioner, the bank started deducting the amount from such pension account. As could be seen from the stand taken by the petitioner, what the authorization given was to recover from the arrears amount of pension payable for the period from December 2014 till March 2018. And 2018. However, this was not paid since the pension was granted to the writ petitioner pursuant to an order passed in a writ petition in WPA 9956 of 2020, dated November 10, 2020, stating that the pension would be payable only from April 2018. Thus, it is clear that the question of arrears being deposited in the writ petitioner's pension account did not arise, and consequently, there was no scope for deduction from the so-called arrears. The learned single bench took note of the decision of the Honorable Supreme Court in the case of Radheshyam Gupta, as well as the scope of Section 60 of the Code of Civil Procedure, and held that deduction from the pension account tantamounts to attachment of the account, and in the light of the specific bar as contained in Section 60 of the Code of Civil Procedure, such deduction was not permissible under law. Furthermore, the learned single bench held that it is a well-settled legal proposition that there cannot be any admission against the law. There is scope of wider interpretation of such concept, since The question here is whether the writ petitioner can take advantage of a loophole of the law by relying on the said provision despite having himself agreed to such deduction. This contention was dealt with by the learned single bench by scrutinizing the relevant documents, and it was held that a careful scrutiny of the admission inverted comma of the writ petitioner relied on by the appellant bank shows that the writ petitioner categorically stated that he was agreeable to the bank deducting the overdue amount from the pension arrears / amount of computation payable to the writ petitioner by the bank. Therefore, the learned single bench, in our view, rightly interpreted the said admission inverted comma is not an admission regarding payment of regular current amounts of pension to the writ petitioner, and the so-called admissions is specifically restricted to the arrears of pension and / or computation payable to the writ petitioner by the bank. That apart, the court, on going through the so-called admission letter, held that an admission should be unqualified, unambiguous and clear. And if the same is not, if those factors are not fulfilled, it cannot be construed as an admission which will be valid in the eye of law. That apart, the learned single bench also rightly held that the writ petitioner is not precluded from seeking shelter under the provisions, under the principle embodied in section 60 of the Code of Civil Procedure. Therefore, the writ petition was disposed of by directing the appellant bank to restore whatever amount of pension, if any, has been deducted from the pension account of the writ petitioner till date from April 2018 on account of outstanding dues of education loan, within a time frame. The learned writ court also made it clear that nothing in the order shall preclude the appellant bank from taking appropriate steps for recovery of dues from the writ petitioner, otherwise in due course of law, by taking recourse to appropriate legal action as permissible under law. Thus, we find the factual position has been rightly discussed by the learned single bench, and as well as the scope of section 60 of the Code of Civil Procedure, and we find no grounds to interfere with the impugned order.
One indulgence, my lord. My lord directed, the court below directed, my lord, the single judge, the petitioner can deduct money from the arrears, my lord. If subsequent event, the petitioner get arrears for the pension, my lord, kindly give us the permission to, we can deduct.
That you do it in a separate proceeding.
Well, 1993, my lord, from now the effect is from 1993, effective date.
Next.
Serial number 2.
The below, lord.
Dismissed.
Let my petition. That this is that matter on last occasion.
Yes, we remember.
Your lordship.
State wanted time to.
For the private respondent number 12 to 15.
I am appealing for the UGC, University Grant Commission.
My lord kindly permits me to appear virtually in this matter.
Yes.
I am for the union, my lord.
Who appears for the state?
Well, I state. We have prepared a report, my lord. And my lord, hand it over, my lord, and then place it.
Yes.
A copy may be given to me.
As per the earlier order, the respondents 11 to 19 are struck off, but the constraint is not corrected.
copy থাকলে তো petitioner
But the correction in the cost title has not been done in terms of our earlier order.
That is the direction was passed upon the registry to do that.
Oh, so you can't do that.
No, I cannot. But in the paragraph 4 of the last order. Therefore, the respondent number 11 and 19 are deleted from the array of parties, and the registry shall carry out necessary correction in the cost title.
So ask them to do
এখানে একটা প্রশ্ন করেছিলাম ইউনিভার্সিটি বলেছে উত্তরটা কোথায় এই যে অ্যান্সারটা এখানে আছে অ্যান্সারটা এখানে প্যাজিনেশন নেই তো
What was the prayer in the writ petition?
Writ petition, my lord, I was praying for CBI
কত নম্বর
reference. No, page 80, 80. Mandamus commanding respondent number 2 and 3 to start investigation in the electronics complex police station case number 2 upon taking the charge from the state police authorities, government of West Bengal.
মার্কশিটও দিয়েছে কিন্তু তাদের সঙ্গে আইআই রুলের কোনো কানেকশন
Initiate.
দিবেন
Now, what happened to your writ petition? So it was dismissed.
My lord, well, in the writ petition, the learned and judge, single judge asked the police authorities to appear before the court and state whether the investigation has been properly done or not. And they appeared and said, no, it is not done in the ambit of the investigation. And then in the single judge passed order directing the same authority to complete the investigation. Well, that is my grievance. My grievance, my lord, this police authority, state police authority cannot complete this investigation. This is a fit case for CBI reference. I will show your lordship. But this is there is national and international ramification. There is involvement of complex issues, and there is moneyed and influential persons are involved to effect the investigation. The person who has made this advertisement, and he is the main instrumentality. By admission, and he has stated that he has taken 3.5 crores for the promotion of this institution.
And who will appear for the 5th, 6th and 7th respondent? 5, 6, 7.
Somebody appeared.
That is Indian Institute of Planning and Management.
They have not filed any affidavit before the trial court.
4, 5, 6 and 7 IIPM
4, 5, 6 and 7. Where is your affidavit of service on 4,
I have given. Filed on last occasion.
No, even on last occasion, nobody appeared for 4, 5, 6 and 7.
We have served. They have accepted the service.
একটু প্যাজিনেট করা থাকলে ভালো হতো অরিজিনাল রিপোর্ট বলে প্রেজেন্টেশনটা করলাম
They are trying to bypass this forum.
জজকে মানে রেফার করাটা মুশকিল হয়ে যাবে
They have not filed any affidavit denying their allegation against them. And the Delhi High Court taken this cognizance of these issues. Delhi High Court by division-based judgment and has decided that IIPM is a fake institution. They cannot confer any degree like a BBA and MBA. And the
now let us see the police report. What
Yes,
the commentary
kindly takes it. Well, there was in the impugned order, there was a direction that the investigating officer would carry out the further investigation in connection with the instant case, taking into account among others the issues relating to respondent number 4 and the authority. So, the investigation was continuing. And whether the respondent number 4 and the authority had any authority to award any degree or not. Now, my lord, your lordship will find the crux of the investigation. Kindly takes from the second page, paragraph 3.
Paragraph 3 of
kindly have
My report, paragraph 3 of my report, my lord, that initially we had filed a report, my lord, stating that it's a mistake of fact. There was a direction for reinvestigation. And my lord, then takes from paragraph 5 that during paragraph 5 in the second page, my lord.
Yes. During investigation, so-and-so issued a letter to the manager, IIPM, and on that basis, IIPM submitted the following documents. A report dated 9th of March 2018, from which it is learned that there was no guarantee of job was given to the student so-and-so. The case was again taken up for re-investigation as per the order of the Honorable High Court. With order so-and-so. In course of investigation, so-and-so issued notice of complaint to the complainant and his son under section 160 CRPC on different dates, so-and-so, but neither the complainant nor his son appeared before the IO. There is a second page, last line. Yes. Then, my lord, IO served notice under section 91 of CRPC to the Vice Chancellor. This I'll place, my lord. This is there in the annexures, my lord. And, my lord, there was a reply to that. And on 13th November 2024, MGU furnished a report dated so-and-so, in which it has mentioned that Abhishek Mukherjee, so-and-so, was the student of Mahatma Gandhi University in the year 2015. And Mahatma Gandhi University has the authority to provide or issue final certificate of completion of a course. Mahatma Gandhi University also issued the statement of marks for semester 1 in the name of Abhishek. It was also issued a statement of marks for semester 2, 3, 4, 5, 6 in the name of Abhishek Mukherjee. After completion of investigation, so-and-so submitted final report in final form as mistake of fact, being electronic PS case number so-and-so. Now, if your lordship kindly take the section 91 notice, my lord, that is annexure 4 to my report. My lord, I'm sorry, my lord, it's not paginated. But annexure 4, it's... That is the seventh document, my lord.
Yes, we have seen that.
Yes. Now, my lord, the reply thereto is 2 pages thereafter. That is 5th December 2024. May I please the responses?
But where is that certificate? It is still lying with the police.
Certificate, mark sheet. Well, we have the mark sheets with us.
No, in the second page, the last page of that report, first paragraph, he said, during investigation, it could be revealed, son of the complainant, Abhishek Mukherjee, took admission MBA so-and-so, seeing advertisement, completed his study. After completion of his course, went to collect the institution to collect education certificate. He got assurance he will get the certificate after Puja vacation in the year 2015. After Puja vacation, when Abhishek went to collect the certificate, he found a FIR named accused. So-and-so closed the institution from Calcutta. Tried to search the institution only. Was examined to comply with the notice under 41A. She had cleared every possible term of the student contract. She left the information about the closer website. Failed to collect the educational certificates from the institutions. Subsequently, result of the course was duly informed to the complainant and the victim, and they were requested to collect the certificate from the PS as per his convenience. Now, is it lying with the PS?
My lord is reading from the report in final form, my lord.
Yes, last page.
My lord, I'm sorry. My lord.
But why have you not collected the certificate?
My lord, they have no authority to confer degree. They, in their prospectus, they have stated that they will award degree. My lord, degree they cannot do. My lord, UGC has given the filed affidavit. They have stated that they have no authority to award degree.
Page number 176.
Page 219, my lord.
119, yes.
And my lord,
Page
There
219.
is a response.
High Court's order.
If suppose UGC says
Where-
that they have not granted any approval,
My lord.
should not have directed the investigation on that angle, because then it becomes a fake institution.
My lord.
Delhi High Court observed that.
It can't be referred as mistake of fact.
No, my lord, it is. My lord, kindly sees their response once to the 91 notice, which I was placing 5th December 2024.
Page?
My lord, that will be the 9th page in the bunch.
Investigating officer.
No, তুমি easy concentrate করো, ওনাকে ছেড়ে দাও, উনি নিজের মতো ফোন নেবেন। My lord, the university says, this 5th December 2024, my lord, it will be about 9th page in the bunch. I'm extremely sorry, my lord, it's not paginated, my lord. that this is response to our queries, my lord. Serial number 1 is MGU is recognized by UGC under the Act of so and so as a state private university. Number 2, there was no agreement in between IIPM and MGU in 2012 to 2015 that Abhishek Mukherjee so and so was a student of the university in the year 2015 and was a student of MGU so and so in the year 2012 to 2015.
So he was a student of that university.
Mahatma Gandhi University.
My lord, 1 minute, my lord. We have no, my clients have no concern with the Mahatma Gandhi University.
Sir, you see this report, Annexure 5A.
I have given him a copy.
It's a statement of marks of Abhishek Mukherjee.
My lord, they are making statement. My lord, then let the
Statement of marks, sir. They are not making statement. It's a statement of mark issued by the university. Annexure 5A. You see the name. Abhishek Mukherjee, father's name so-and-so Mukherjee.
12 to 2015.
Course is BBA. He is a student of Mahatma Gandhi University. This fellow went and joined this particular IIPM on seeing an advertisement. Okay. So according to you, this is a fake institution. Therefore, they have to be brought to books. That's your contention. First, why don't you collect the mark statement which is lying with the police station? We will ask them to return it. First, you take that document out of the police station. First, you take the mark statement from the police station.
My lord.
It is in the interest of the student. We are suggesting that. Please see the report, last page, fourth page.
Yeah, last page.
Inspector of Police in charge, Electronic Complex Police Station. No, sorry. That final report. Last page of that bunch.
My lord.
Unnumbered paragraph 3. Last 3 lines. The last line. The statement of marks are yet to be collected by the complainant or his son Abhishek Mukherjee. First, you collect it from them.
Yet to be collected.
First, you collect it. Then we will see what has to be done to this. And one thing, ground pleader, if the UGC has given a state,
That it is not recognized.
Taken a stand that it is not recognized. Then if he has made an advertisement as if he has got a recognition or not affiliation, recognition, then that angle has to be investigated.
Well, whether there is any investigation on that part or not specifically, I'll take instructions with regard to that. I have given him the copy of the report. Let him go through it also, Malad.
Now, where is UGC's report? Page 9.
219.
Malad, I have a very short submission, Malad. I appear for HDFC Bank, Malad. The initial grievance of the petitioner is only against IIPM. If your lordship sees the 156 application, only IIPM is the accused. Then it was investigated, a final report was filed. They filed an Arazi petition. In the protest petition, they have made HDFC Bank, its MD, its board members, everyone a party, without ascribing any specific role.
Mr. Chatterjee, I think you have not seen our earlier order dated 24th March. Respondent number 11 to 19 have been deleted.
My lord, if I have correctly understood, it was 11 and 19.
12 to 15 Oh, 11 and 19. Oh,
yes.
And what is the allegation against the bank?
My lord, there is no allegation. We gave an education loan. His allegation against IIPM, suddenly in the protest petition, they include the name of the brand ambassador, the bank, bank's MD, bank's board members, everybody has been included.
But because they have extended their loan facility to the fake institution for commission of fraud. And
that is a commercial transaction. If they have availed a loan, they would have secured the transaction. Now your case is this institution should be brought to books. In that process, you don't drag. This was never your case initially. In the first
No, my lord.
You have lodged. There is no allegation against the bank.
My lord, kindly, my lord, comes to 154
My lord, one
once.
thing, my lord.
What was the allegation?
Against them, we had made an FIR complaint before the Hershey's police station, and that they have assisted the commission of fraud. That
My
has
lord,
not been considered
this
also.
submission is without any legal foundation. My lord, kindly comes to page 154 once. The 156 application, which has led to registration of the case.
Yes.
Only one accused, International Institute of Planning and Management. And their lordship, they say we have taken a loan, bank has approved, has granted the loan, disbursed the loan, with that the admission has taken place. Now, my lord, the protest petition is at page 166.
Yes.
Yes, their lordship kindly turns to 167, the first paragraph. Mr. Shah Rukh Khan, film actor, HDFC Bank, Gilender House, its managing director Aditya Puri, its branch manager Surinder Singh, Mr. Soumitra Sil, senior executive of its branch of the said bank, is also party to the said fraud scam, headed by Anirban Chaudhary, the head of the said IIPM institution, and the wife of Rajita Chaudhary. This is where, my lord, in the protest petition, only there the bank has been implicated.
All right. Sir, please take note.
My lord, I am praying for expunging, my lord, the name of the bank and
please.
I'm grateful, my lord.
Reference may be made to the order dated 24/3/2025, which reads as follows. The registry is directed to carry out the direction wherein direction was issued to delete respondent number 9, 11 and 19 from the array of parties. This should be done within 2 days from date. The learned senior standing counsel appearing for the state has filed the written instructions given by the inspector in charge, Electronic Complex Police Station, Bidan Nagar Police Commissionerate, dated 6/4/2025, along with annexures. We have gone through the said report, which is addressed to the learned ground reader, along with the annexures, and it appears that there was initially an officer who had investigated the matter, and pursuant to the a final report mistake of fact was registered, and subsequently pursuant to orders passed by court, the reinvestigation was taken up, and a final report has been filed. Once again, reiterating the same stand as mistake of fact. In the said final report dated
the pursuant order of investigation. Finally put on the last
28/2/2025. Among other things, it has been mentioned that the second appellant, Abhishek Mukherjee, had completed the course but failed to collect the educational certificate from the institution. The institution took a stand before the police that the result of the course was duly informed to the first petitioner, first appellant, namely the complainant, and the second appellant, who's the son of the complainant, and they were requested to collect the said certificate from the police station as per his convenient date and time. Further, it is stated that the statement of marks are yet to be collected by the complainant or his son Abhishek Mukherjee. Before we proceed to examine as to what directions have to be given in this petition, we direct the appellants to approach the concerned police station and collect the statement of marks, which is said to be lying with the police station, and report to this court about compliance of the said direction. The second aspect is whether the HDFC Bank, which appears to have extended certain financial assistance to the fourth respondent institution, it's a proper and necessary party to the petition. They have been implemented as respondents number 12 to 15. The 12th respondent being the bank, the 13th respondent its managing director, 14th respondent the director, and the 15th respondent a senior executive attached to the Kolkata branch of HDFC Bank. The learned advocate appearing for the bank has submitted that in the complaint, in the application filed by the appellant's complainants under section 156 within bracket 3 of CRPC before the learned Chief Judicial Magistrate at Barasat, which was taken on file as C case number 2859 of 2015, there was no allegation against the bank or its managing director or its director or its senior officials. And for the first time, the said complaint was investigated, and the case was referred as mistake of fact by report dated by final report dated 30/11/2016. Thereafter, the complainants / appellants had filed a protest petition on 28/6/2017, wherein there is an allegation that the HDFC Bank and its officials are also party to the fraud / scam headed by sixth respondent and his wife, the seventh respondent. We find this allegation to be absolutely vague and it's a clear afterthought. And unnecessarily, the bank has been dragged into. The transaction between the sixth and seventh respondent and the HDFC Bank is a private commercial transaction, and it can in no manner be germane to the allegation made by the appellants against the sixth and seventh respondent as well as the institution which was founded by them. Therefore, we find the respondents 12, 13, 14, and 15 to be neither proper nor necessary parties to this appeal, and accordingly they are deleted from the array of parties.
I'm grateful.
The registry is directed to make necessary correction in the cost title within 2 days from date. After we have gone through the report submitted by the police along with the annexures, we find that the investigation did not, we prima facie find that the investigation has not proceeded, has not taken note of the public notice issued by the University Grants Commission in July 2012. By the public notice, UGC informed the public at large and students that IIPM, which respondent? The fifth respondent is not a university within the meaning of section 2 within bracket F of the University Grants Commission Act 1956. Full stop. Further, as per section 22 of the said act, the fifth respondent does not have the right of conferring or granting degrees as specified by the University Grants Commission under section 22 within bracket 3 of the act. Full stop. It was further clarified for information that the fifth respondent is neither entitled to award MBA/BBA/BCA degree, nor it is recognized by UGC. Therefore, the public and the students were informed that only universities established either by a central act, a provincial act, or a state act, or an institution deemed to be university under section 3 of the act, or an institution especially empowered by parliament to award degree, can confer or grant degrees which are specified under the 1956 Act under section 22 within bracket 3. A list of degrees specified by the UGC was made available in its website for the information of all concerned. Prima facie, we find that this aspect of the matter has not been investigated by the respondent police.
Kindly have a look to page 23, the learned single judge order specifically there was direction and that the investigation.
Where is that Mahatma Gandhi University?
Page 175 also one.
Statement. What is 175? That is also same notification.
Already yes. 2007 notification.
Pardon? Page 175 is the very same notification which we have referred. Where is that Mahatma Gandhi University's letter?
Yes. And our affidavit I have also.
You showed, no? Where is that letter?
Affidavit.
There is no letter from Mahatma Gandhi University.
Page 126, my lord.
Well, letter I produced is in my 9th page.
Further, we note that further from the annexures to the report submitted by the Inspector of Police, 120. Inspector in charge, Electronic Complex Police Station.
Kindly one thing.
Wait, sir. We find that the Mahatma Gandhi University has addressed the Sub-Inspector of Police by letter dated 5/12/2024, wherein it has been clearly stated that there was no agreement between the fifth respondent, namely IIPM Calcutta and Mahatma Gandhi University during the period 2012 to 2015. Furthermore, it is stated that the second appellant, Abhishek Mukherjee, was a student of Mahatma Gandhi University, Meghalaya, from the year 2012 to 2015, and copy of the mark statement has also been enclosed. If such is the stand, the investigation should have proceeded also in the said direction, since the university, Mahatma Gandhi University, has stated that there is no agreement between IIPM Kolkata, which is the fifth respondent, and the Mahatma Gandhi University. From the closure report dated 28/2/2025, we find that this aspect of the matter has also not been investigated. Therefore, the officer in charge, Electronic Complex Police Station, Bidhannagar PC, is directed to show cause as to why the matter should not be directed to be handed over to the what is it? CBCA. No, CID. To the CID for a fresh investigation. Upon letter report in the form of an affidavit be filed by the concerned investigating officer covering the above aspects. Deleted. So first you go to the police station, collect the statement of marks. Then they will find file a report why it should not be transferred. Let us.
I may be permitted to file an affidavit to that respect.
Yes.
And my lord, other thing, my lord, the report filed before your lordship, I may use affidavit to that report.
Liberty is granted to the appellants to file exception to the report filed by the police.
Yes.
No, after 3 weeks, 3 or 4 weeks. Next.
Serial number 3.
Your lordship.
Which petitioner is appellant before your lordship?
But I am for the state, I am also.
Madam, kindly go through the order impute, which I have challenged. Learned single page while observing that he has no scope to interfere in the writ petition, he made the observation regarding by infringing my fundamental rights. The dispute is, my lord, by virtue of a deed of petition, I was allotted, I am in possession in respect of a portion of a property where from I am conducting my business, electrical goods business with a valid trade license. Now, my lord, the others were also the co-sharer, not in respect having the demarcated share over there. What have they done? They had organized Durga Puja each and everywhere by covering that shop room. So right to trade has been seriously infringed. This is the simple issue where there is an other spaces. I am not standing on the way to performing Durga Puja. But the particular place where my shop room, they are doing so intentionally only to hamper my business or otherwise. Well, this is my grievance. Now, my lord, a civil suit is pending.
Durga Puja is not celebrated throughout the year.
Not celebrated throughout the year. But it was when it was happened, then the this issue was there. Now Durga Puja was over. Then now this year again Durga Puja will come. Again my shop will be obstructed. Now, my lord, how many times I will come? There is a civil suit. Administrative civil suit, there is a declaration and injunction, and subsequently I got a status quo order in respect of proposition. I have the copy with me. Now, my lord, if it is so, the question of determination of I have a purchase everything. If a determination of my possession, etc., that will be determined as civil letter. I bow down before your lordship. My lord, there is a other space in that area to perform the Durga Puja. I never stand on the way. Only leaving my place. This is the simple issue. I am not, my lord.
What happened in your writ petition?
Yes.
What is the order which was passed?
My lord, kindly come to the order impute, my lord. My lord, this is may I read the relevant portion? The second page, 1, 2, 3, 4 paragraph. There is no scope within the writ petition to adjudicate the rights of the parties. The court is primarily concerned with the performance of Durga Puja this year as has been done in previous years. It is undisputed that Durga Puja has been performed at the said premises since 2021. It is expected that the petitioner and respondent numbers 9 to 12 will conduct the festival together in a spirit of joy and festivity. The rights of parties in the civil suit and the ownership of the disputed structure will be determined by the competent civil court. Until such dispute are resolved by a decree of civil court, the parties should jointly conduct the Durga Puja in a congenial atmosphere. Then it appears that there are 5 families descended from the late Bhuvan Chandra De, respondent number 9, however, claims that Durga Puja is being performed solely at his expenses. Regardless of the ascertained, respondent number 9 shall allow other family members to participate in the rituals to maintain the festive spirit. This order is passed without prejudice the right and contents of the parties in the pending civil court. My issue is not that. My simple issue, perform Durga Puja, whatever you like, my lord, don't interrupt my fundamental right to trade.
That is also.
But the writ petition.
No, that is also a civil right.
My lord, absolutely. I bow down before your lordship.
Suppose there is according to you, you have obtained an order of status quo.
My lord.
Status quo as regards the character of the property or physical possession, etc.
No.
If there is a violation of the status quo order, your remedy lies not with the writ court. The writ court is not the executing court for the civil court order.
My lord, may I pay one
You could have filed a petition for contempt before the civil court saying that this order of status quo has been violated.
May I trying to, my lord, answer your lordship, my lord. This status quo order passed subsequent to the passing of this order. At the time of entertaining of this writ petition, entertaining writ petition, civil suit was pending. What is the nature of the civil suit? That is declaratory suit filed by me, that by virtue of a deed of partition, I was allotted with this portion. Don't disturb my peaceful possession. Now, my lord, where the, my lord, learned single judge was pleased to observe that the writ court has no scope to entertain, but subsequently what has...
Please show the status quo order.
My, the portion is a duto copy now. Only leaving my front side anywhere. Without obstructing one another. That portion.
This order was passed on.
First page is not there. In the month of 6 April. So
What is the date of the order? The case was
5th October, my lord. 5th October is the date of the order. In the writ petition, suit suppressed. We brought it to the notice of the court. In the stay application,
after the
status quo suppressed.
parties were heard, some sketch was also produced.
Yes.
Photographs of Durga idol, etc.
Yes.
You take advantage of this order.
My lord.
Kindly seize the last line.
May I?
No, all
may I?
the,
Sure.
see,
I'll
this,
give.
this
These are, my lord, may I? One indulgence only. My lord, the ordering portion is the parties shall maintain status quo as regard their possession and usage of the suit plot number such and such without obstructing one another till disposal of the suit. Now, my lord, I am bowed down before your lordship, my lord. Absolutely, if there is any violation on forthcoming puja, upcoming puja, then again I have to approach. Now, how I approach? I have to file a other 151 CPC before the court below. If I file that 151 CPC when it was on Panchami or Chaturthi, court will remain closed. My lord, kindly see, observe. Then, my lord, they will file their objection. Then it will be decided. My lord, why? What will I do if a simple?
We can't.
Because writ court order is standing on this way.
True, we will clarify that this writ court order cannot travel beyond the puja for the concerned year. That's it.
I'm grateful.
That is enough. Because admittedly this order was passed in October. After the writ was disposed, we can say that this order cannot be taken advantage for the ensuing pujas. That's it.
I'm grateful.
My lord, my kindly records, my lord, my submission first is that writ petition was not maintainable.
You are not an appeal.
It's not an appeal. Yes, should have been dismissed in view of the fact that it doesn't express and say that suit is pending. It is we who have brought it to notice of the court, and this order has been passed with during the festivity. So therefore, the festival orders, I understand, my lord. What second is, before your lordship, this order of status quo was not.
You can't use the deity to.
Kindly seize this status quo order. As it is necessary to protect the possession of the plaintiff, which has been prima facie shown, it is also necessary that no interference is caused to the defendant who are in possession of the remaining portion.
Because you filed a map, they have photographs.
And kindly seize, this is the mondop, which is far away, and here somewhere here is this photograph. Somewhere here is
I'm disputing this photograph.
His my lord. Obviously, you will dispute. That has to be decided by the civil court.
There is no exchange of affidavits before the court below, where the writ court says that there is no scope in the writ petition, but pass the order in
for the last five years, my lord. We have documents.
I am disputing that fact also.
Yes, I am disputing that the matter should not have been taken up.
This intra-court appeal by the writ petitioner is directed against the order dated 25/9/2024. If it is established 24382 of 2024. The said writ petition was filed by the appellant paying for issuance of writ of mandamus to restrain the respondents from disturbing or interfering with the possession of the petitioner in respect of the premises in question. The learned writ court had disposed of the writ petition with certain observations. The learned counsel appearing for the appellant is right in contending No, sorry. The learned Writ Court was right. Coming to the conclusion that there is no scope within the writ petition to adjudicate the rights of parties, especially when civil suit entitled suit number 414 of 2024 filed by the appellant writ petitioner is pending before the civil judge within bracket junior division, second court, Paschim Medinipur. The appellant is aggrieved by the other observations which have been made by the learned single bench concerning the performance of Durga Puja for the year 2024. It is seen that after the writ petition was disposed of, the civil court has passed an order of status quo in October 2024. And the case was directed to be heard for framing of issues on 8/4/2025. Obviously, this order having been passed subsequent to the disposal of the writ petition, could not be subject matter of the case, and it has been produced before this court for the first time. Since the civil court is now seized of the matter and as a prime facie adjudicated the rights of parties and come to the conclusion that it is necessary to protect the possession of the plaintiff, which has been prime facie shown, and it is also necessary that no interference is caused to the defendants who are in possession of the remaining portion of plot number 121 bar 376 jointly. Therefore, in our view, the observations which have been made by the learned writ court concerning the Durga Puja can at best be confined only for the puja which was conducted during the period 2024, during the year 2024, and not for any subsequent years. Therefore, we dispose of the appeal by making an observation that the findings rendered by the learned single bench with regard to the performance of the Durga Puja is restricted only for the puja which was already over in 2024 and cannot be referred to or taken advantage for the puja for the year 2025 or for any subsequent years. The parties are at liberty to agitate all the rights in the pending civil proceedings. Yes.
Can you also record that we are also performing the puja from 2021 as recorded by the
No. Milord, that's I am disputing, Milord. There is no such.
Next.
I'm good. For affidavit service. Milord, affidavit service we kept in the record.
Lordship, in item number 4, I am paying not this week because Milord injunction can number 2 Milord has been affirmed by last Thursday Milord. That has been sub later on Milord kindly. Milord, in the meantime, I am giving liberty some correction Milord which to be made page number 8 and 12.
All right. Liberty is granted to the learned advocate for the appellant to make necessary corrections to the page numbers.
Page number 8 and 12.
In pages
there is
8
some
and
clerical
12,
mistake.
And also file can 2.
Can 2. Well, there is an interesting matter, Milord. There is a settled principle. If fraud has been committed by the staff of the LIC, this is the LIC matter, why investors should suffer? That is the principle of law.
Next.
Serial number 5.
I am for the appeal.
I am for the writ petitioner, respondent number 1.
I have filed the appeal along with the section 5 application. This is a case where the Pirottar properties, that means Devottar, like Hindu Devottar property it is called, in Muslim Pirottar property has been converted into a personal property without the order of the court, and it has been recorded in his name and he is cultivating. And the learned trial judge has passed an order. If your lordship kindly come, page 51 of my stay application.
You challenge that conversion order?
Yes, my lord. I have challenged the conversion order.
No. You are not the writ petitioner.
Yes, I am not the writ petitioner. We are the respondent. Behind our back, the order was passed.
First respondent.
Private respondent.
You are the first. Private respondent.
We are the villagers who are protecting the property of Pirottar. We are the private respondent.
No notice was served upon us that it will be moved before another court.
Where is the copy of the writ petition?
Not annexed. With the stay not annexed.
You have not implemented them.
Yes, they were there. But kindly come to section 5 application, what they said, my lord. Kindly come to. But paragraph 3, they stated, the applicant state that they received a copy of the writ petition being WP number so-and-so along with a forwarding letter dated so-and-so of Sri Shantanu Hazar, learned advocate of this honorable court, informing that the said writ petition should appear before the bench of the Honorable Justice Joy Gupta on 23rd of February 2024. After receiving the said letter of the learned advocate of the writ petitioner, the applicants herein immediately engaged Vandana Mondal, learned advocate of this honorable court, to take steps in the matter on their behalf. That the learned advocate of the applicants was watching the matter in the daily cause list of hearing of the Honorable Justice Joy Gupta, but the matter was not taken up for hearing on 23rd of December 2024. That the state that learned advocate informed them the matter was not taken up. Now, paragraph 7, that the learned advocate of the writ petitioners didn't serve any notice upon the applicants nor upon the learned advocate, informing that the writ petition would be taken up for hearing by Honorable Justice Amrita Sinha. But change of determination, matter was all alone in the list. It's my fault that I couldn't, my lord, intimate him.
All right. What was the relief you sought for?
My lord, 2003, the correction was made. 2023, they challenged. Before the BLLRO, BLLRO negated their case. They preferred an appeal under section 54. That was also negated. Yes, that was cancelled. Yes, that was cancelled. I have annexed all those things. That was cancelled. Now, Malad, they were creating disturbance on my agriculture. I pray for protection. But if your lordship stands to page 23 of the stay application, that's the correction of 2003 itself.
(11/7/2003).
Yes, that was the correction made in our favor. Then, well, they preferred an application before the BLLRO, page 39. That is in 2023. That was rejected, page 43, the rejection order. Page 42, the last order dated 1st of March 2024. Lordship got it? The correction which was made in 2003, that was challenged by them in 2023, that has been rejected by the BLLRO in 2024. Now they preferred an appeal, page 45, under section 54.
Your lordship, kindly page 43.
Page 45, my lord, kindly come. The page 48 is the, my lord, concluding portion, the ordering portion. The appeal under section 54, that was also, my lord, rejected.
Then why did you not prefer
the original application before the LRTT? They should have been filed.
You should have gone before the tribunal.
No, page 43, your lordship, kindly come. BLR's order, thus the instant petition is not considered. Is not considered.
Filed by you.
Then you filed an appeal.
Appeal court also did not consider the merit of the matter.
You should have gone before the.
I will file the application before the land tribunal. That is a different matter. But in the meantime, the trial.
Trial court the series of 3 orders are against you.
Against you, but
against the appellant.
No, not 3 orders.
Yes. Original authorities order.
No, that order, if your lordship kindly come to that, that was passed behind our back. I do not know. In collision with the BLRO, that order was passed. May I read that?
We cannot test the correctness of the BLLR order.
My lord?
You cannot challenge the BLLR order here.
No, I am not challenging here. I am challenging the order of the landed trial judge, who, that was admittedly Pirottar property. That is the property of Devottar property.
That has already been changed in the revenue record.
No, that cannot be done without the court's order.
Therefore, we are not saying that you don't have a case. You are not before the proper forum. You should have gone to the tribunal.
I will go to the tribunal. I have stated in my petition that we have decided to go to the proper forum.
Or the direction issued by the learned writ court is that there is a likelihood of breach of peace. Yes. Therefore, strict vigil has to be maintained.
We have 107 proceeding has been initiated by us.
No, difficulty is that admittedly this is a Pirottar property. That cannot be changed. If your lordship kindly come.
This intra-court appeal by the private respondent in WPA 3908 of 2024 is directed against the order dated 9/7/2024. The said order directs the officer in charge, Daspur Police Station, to keep strict vigil over the locale and ensure that there is no breach of peace at the time of cultivation of the land by the respondent writ petitioner. The appeal is barred by time, and there is a delay of 240 days in filing the appeal. As on going through the affidavit filed in the support of the petition, the application, we find that the appellants were served with notice and they have represented by their advocate, and the matter was subsequently allotted to a different honorable single bench. On account of change of determination, the appellants did not appear. Therefore, this can never be taken to be a sufficient cause. However, since the learned advocate for the appellant insisted upon making submissions on merit, we have considered the same as well. Admittedly, an order was been passed for conversion on 11/7/2003 by the revenue officer, BL and LRO Daspur 1. This subsequently a miscase was filed, and the same was rejected by the prescribed authority by order dated 1/3/2024. Against the said order, an appeal
Under
was
section
preferred
54.
to the
Is 45 is the Malad appeal.
appellate authority
48, second
under
paragraph.
section
It is
54
ordered
of
that I have
the
not
Land Reforms Act
divert into the merit of the
1955,
claim.
which has been dismissed.
The merit of the claim has not been decided.
Dismissed by order dated 16/12/2024. If the appellants were aggrieved by the said order, they should have preferred, they should have approached the tribunal.
But we have not yet approved the time.
Now,
We
which
have
they have
decided.
not done till date. In the facts and circumstances of the case, this court cannot adjudicate as to the nature of the property, since the allegation of the appellants is that the property is a dabattar. What is it?
Spirottor, Malad.
In Muslim law, it is called
Pirattor property.
not the
As long as the revenue records stand, revenue records shows the land otherwise, and unless the revenue records which shows the land otherwise is challenged and the order has been set aside, this question of entertaining a challenge at the instant of the appellant would not arise. Thus, we find that neither the appellant has shown sufficient cause for condemnation of delay, nor the appeal merits consideration. Accordingly, the same are dismissed. Sorry,
Great,
sir.
Malad.
Next,
Serial number
Still
6 before the tribunal.
limitation.
My lord. And that should be decided on merit.
Item number 6, my lord. I am for the respondent led by Mr. Shomik Ganguly, my lord. He is engaged in another.
My lords, for the CSC Limited, just one submission, my lords. Possibly the appeal is infructuous because we have carried out and implemented the writ court order, installed the meter on 3rd of April.
That has been carried out.
The learned advocates appearing for the appellant and the respondents agree that the direction issued by the learned single bench has been carried out and the appeal has become infructuous. According to said submission, the appeal stands. Next.
Serial number 7.
So I pay for the state respondent.
The order, my lord, impugned is dated January 17, 2025. Passed by the Honorable Single Bench, my lord, if your lordship may kindly peruses the order.
It's 54 years.
What happened before the
What
magistrate?
happened, my lord? my son was found, my lord, lying in the road, beside the road, along with a pillion rider, my lord, at 7:30 in the morning. My lord, what we get to know that the private respondent was taken to a hospital, and my son was left to, my lord, die at that spot for 2 hours. After 2 hours, he was taken to the nearest, my lord, the rural health center. My lord, there it was declared that he was dead. My lord, that day nothing happens except and apart from an UD case. My lord, unnatural death case was raised. Subsequently, on the next date, my lord, on the basis of our complaint, the FIR was lodged, and that is under section 302, my lord, as against the private respondent. My lord, the police investigates, does not do anything. My lord, we have repeatedly submitted our prayers that please at least, my lord, seize the important and significant evidence, including, my lord, the kind of a phone that he was having. It is a, my lord, an iPhone, which has, my lord, sufficient, my lord, evidence, because the iPhones can, my lord, record a lot of things, but there are applications, your lordship. My lord, nothing was seized, my lord. At that juncture, my lord, before the honorable single bench. If your lordship may kindly peruse the orders passed by the honorable single bench, my lord, the honorable single bench, my lord, took notice of the, my lord, irregularities done by the investigating agency. My lord, her ladyship called for a report. The police comes and submit the report. The report was not satisfactory. Her ladyship, my lord, directed them to submit an upgraded. My lord, at this point of time, the police submits a final report saying mistake of fact in the lower court. My lord,
and you have filed a protest petition.
My lord, this is prior to that. My lord, we have not. We have sought time before the learned magistrate. My lord, prior to that, we have approached this honorable. My lord, what happened? My lord,
then we do one thing. We'll keep the appeal pending.
My lord,
because that final report has to be reopened.
My lord, my lord, I bow down. Only one thing, my lord, what her ladyship directed the learned magistrate, that the prayer for change of investigating agency shall be looked upon by the learned magistrate.
That can't be
power,
done.
My lord,
That can't be done.
My lord.
The magistrate can order for fresh investigation or re-investigation.
By the same police station, my lord, by the same investigating agency, which, my lord, will not, my lord, result in any positive.
First, you see that as of now, the final report stands.
My lord.
If you file a protest petition, then the finality of the final report gets lifted. Then it will be easier for this court to examine whether what to be done.
I bow down.
Whether it ought to be shifted to the
down.
CID or shifted to some other Superintendent of Police to nominate some other senior officer, etc.
I bow down. I'm grateful, but my lord, before your lordship, I need not
already filed lordship. Can you lordship come to the next page of the order, lordship?
Order?
Next page of the order, at page 25. Paragraph 4 and 5.
That is probably, my lord, I placed.
Yes. Upon hearing the parties and on the appraisal of the documents placed before this court, it appears that the learned magistrate has already posted the matter on such a date upon notice to the de facto complaint. Next, paragraph 5, your lordship. It will be open for the de facto complaint to address the court with regard to the prayer for the change in the investigating agency and loopholes in the final report that has been filed.
Magistrate doesn't have power to change. Where is the final report?
Lordship, final report is at page, my lord, 181 of the application. Lord, a death has happened. It might be the case of the investigating agency that the private respondent has complained. My lord, they did not find anything against the private respondent. But, my lord, the death has happened. How can there be a mistake of fact on that?
Magistrate means also jurisdictional court, your lordship.
And before your lordships, I need not cite any judgment, but, my lord, if your lordships may kindly consider that even at this stage, your lordships have the power, my lord, to direct, my lord, investigation by a, my lord, a superior or a more experienced investigating agency, my lord, without going before the learned magistrate. 174, 176 CRPC, my lord, have been, my lord, overlooked. Nothing was done. No magisterial inquiry, nothing. While, my lord, the honorable single bench was in session of the matter, was monitoring the investigation, the investigating agency, my lord, submits the final report. And that is to, my lord, stating mistake of fact.
the trial is begins, your lord.
Deliberately, my lord, make the writ petition infructuous.
Who is this MS Polumi Das?
My lord, pillion writer.
Why did he apply for anticipatory bail?
My initial complaint was against her.
She was riding with her friends. Right. She was riding with him at the time of the incident.
See, if it is a case of a road traffic accident,
Lordship.
based on the injuries which have been noted at page 185 and the crushed helmet, the police should have been able to find out against which he collided, either an oncoming vehicle or a vehicle which was stationary vehicle or on a median or a lamppost.
Grateful, ma'am.
Something should have been, plus the damage to the two-wheeler, that also should have been assessed.
Lordship.
We will be able to find out if suppose it was a act like he was driving in breakneck speed, there was a curve, or it was raining, the road was slippery, therefore he went and dashed against something. That is missing. Against which he dashed. Because the other lady who was a pillion, she has survived. One more allegation is that she was taken for treatment immediately. This fellow was left with this bleeding injuries for nearly 2 hours. Who took that lady to? She's a doctor, is it?
Both were dentists. Both were dentists. The police took the lady. Police took the lady.
So why they should leave him?
Why they left him? Well, this answer, my lord, we have not yet received.
On this
and
one,
the lordship kindly refuses.
Which is the document which you rely on to show that the lady was took for treatment immediately?
Yes. So that is from there. That is from the statement, my lord, the 164 statement of the witness.
Suparna Maji.
Yes, my lord. Yes.
Wife of Abhijit Maji.
Yes. My lord, it is in Bengali. We have, my lord, submitted a 164, page number 164 is the translated version. My lord, last line of that 164 statement. The police took away the woman at first and then the ambulance came and took the man later. page 164, my lord. It's the translated version of the Bengali
164.
164.
Page 164.
Here it says a small lorry was parked adjacent to the highway at a lower level.
Yes.
The motorcycle banged from behind and hit hard at the backside of the small lorry. I heard a loud sound. Driver thought for a moment that the tires burst and he was trying to locate if there is damage in his car or not. I saw a motorcycle was lying in the bushes upside down, a pool of blood. I was extremely scared to witness the horrific moment. I immediately fled from the place of occurrence and left my home. The driver of the small lorry too fled from the place of occurrence. There were two persons in the bike who were one man and one woman, telling the other, the lady has said, no. The police took away the woman at first, then ambulance came and took the man later.
This and my lord, page 168, the Honorable Single Bench's order, my lord. Paragraph 5. The police was, my lord, clearly directed to, my lord, apprise her ladyship what happened to the, my lord, the offending vehicle. And
in the final report, there is no reference to that lorry. Sir, assuming even though their first complaint was against that lady, doctor, that complaint, let us say that it is false. But still, it is a case of, even according to your road traffic accident. Whether there was a contributory negligence on the part of the deceased or somebody else was the cause of the accident, whether the vehicle should have been parked, that aspect has not been investigated at all. This will affect his claim for compensation also.
My lord, forgetting compensation, my lord, the parents, my lord, they are, my lord, horrified, my lord, they are helpless. They are not, my lord, claiming for any compensation, but this.
Why is the apprehension about why did you lodge the complaint against the pillion rider?
When
Because she was the pillion rider.
One,
I mean, what
she
else?
was the pillion rider. Second, my lord, the information about my son's death, my lord, comes from her parents to the security guard of my apartment. Whereas she very well knew our phone numbers and everything. But
I mean, there lies the apprehension that she is involved in this accident.
We apprehended that she might be involved. She might have some connection with the death
But
of
she was also injured.
Very minor injuries to our knowledge, very minor injuries. She did not suffer with
Also, I have to take some instruction on this.
She did not, my lord,
I
suffer
some
any fatal
instruction.
injury, and which is, my lord, highly improbable. A person dies and the pillion rider, my lord, survives without any injury.
And the presence of the also required your lordship private respondent, your lordship.
This is
respondent number 9, your lordship.
And the injury suffered to my son, my lord, cannot happen while he was wearing a helmet.
Where is your complaint? First complaint.
My lord, page number 57. "57, my lord, is the formal FIR. 58 is the written complaint.
So the allegation is it was an attack on the forehead after the helmet was removed. Because the injury is noted at page 185 of the final report.
But post-mortem
Lacerated
report
wound,
is
scalp, bone, brain cavity present vertically over in frontal and in the eyebrow area with commuted fracture at the side, so and so, so and so. Part of the brain matter, graze aberration, forearm. Lacerated wound present over, side upper lip.
photographs that were provided by the police. In one photograph we are seeing that the son was wearing the helmet. If he was wearing the helmet, that injury is highly improbable. Highly improbable.
No, there will be cases where on account of the road traffic accident, the impact, the person get crushed with the helmet.
Yes.
If they are run over by a vehicle, they get crushed with the helmet. That is not the case here.
Not a case here.
Also, allow me to take some instruction from the concerned authority.
Or what we can do is, the learned judge was said that he can go for the magistrate to seek for change of administration, which can't be done. And this will fall within the jurisdiction of Superintendent of Police, Hooghly Rural.
Probably Chandanagar Ballot Commissionerate.
Hooghly Rural.
Hooghly Rural.
Hooghly
Police station is-
Chunditala will be Hooghly Rural.
So,
Hooghly
so
Rural.
it will be then Superintendent of Police.
My lord.
SP Chunditala. You are writing the press investigation.
Yes, my lord, Hooghly Rural, my lord.
That
I
is
stand corrected. Hooghly Rural.
This intra-court appeal by the writ petitioner is directed against an order dated 17th January 2025 in WPA 20043 of 2024. The said writ petition was filed by the appellant for a direction to forthwith take steps by transferring the Chanditala police station UD case number 61/24 dated 10/6/2024 and Chanditala police station FIR number 410 of 2027 to the respondent number 7, namely the additional director from a Central Investigation Department, West Bengal Police Directorate, having office at Howrah. When the writ petition was being heard, certain orders were passed by the learned single bench. Where is that order you showed? Interim direction one.
My lord, the first order passed by the Honorable Single Bench, my lord, 27. This is, my lord, 17th of September 2024.
The last order.
Page 152 is the first order, my lord.
152.
152.
What? Passed. And the order the order dated 17/9/2024 is quoted here and below. It is page 152, 153. Subsequently, where is the next order?
My lord, page 168 is the next subsequent order, my lord. 8th of January.
Subsequently, no. In terms of the above direction, a report was filed by the officer in charge, Chanditala Police Station, signed on 4th October 2024, which was taken on record. The submission made on behalf of the appellant that the police are not conducting the investigation in a proper manner and the digital evidence have not yet been seized from the not yet been seized was recorded by the learned single bench in the order dated 8/1/2025, which reads as follows. Please quote that order. In terms of the above order, no, it was second. It appears from the above order the learned single bench was not satisfied with the report filed on report signed on 4th October 2024. Therefore, a direction was issued to file an updated report which shall specify the identity and the details of the offending four-wheeler and shall also mention as to whether driver/owner of the offending vehicle was arrested or not. Subsequently, the matter was heard on 14/1/2025 and a report was filed. Report dated 13 January 2025 was filed, which was taken on record. And a copy was directed to be filed, served on the learned advocate appearing for the appellant writ petitioner. When the matter was pending consideration before the Honorable Single Bench, a final report dated 20th December 2024 has been filed by the investigating officer, stating the case to be a mistake of fact. When the matter came up, when the writ petition came up for hearing subsequently, the above fact was brought to the notice of the court and the writ petition stood disposed of by the impugned order dated 17th January, in which the learned single bench has recorded that the learned magistrate has already posted the matter on 18 January 2025 upon notice to the de facto complainant / appellant, and that it will be open to the appellant to address the court with regard to the prayer for change in investigating agency, and the loopholes in the final report that has been filed. The learned magistrate was directed to take a decision in the matter upon hearing the parties. To be noted that the learned magistrate, while considering a protest petition filed against a final report stating stating it to be a case of mistake of fact, can consider as to whether the investigation was appropriate and is confined with power only to order re-investigation and not for change of investigating agency. It is not clear as to why the respondent police were in such a hurry to file a final report stating the case to be a mistake of fact on 20th of December 2024, when the learned writ court has, when the writ petition was still pending and the learned writ court was monitoring the matter, and the initial report filed by the police was found to be not satisfactory, and an updated report was directed to be filed, copy of which was only furnished to the appellant writ petitioner pursuant to order dated 14 January 2025. Therefore, it appears to be a matter where the attempt was to make the prayer sought for in the writ petition infructuous. Be that as it may, having held that the learned magistrate will have no power to change the investigation agency if it is found that the investigation was perfunctory, we are inclined to interfere in the matter. Apart from that, when we peruse the final report, we find that the specific direction given by the learned single bench, while not accepting the initial report and directing filing of a updated report, directed that the updated report shall specify the identity and the details of the offending four-wheeler and shall also mention as to whether the driver/owner of the offending vehicle was arrested or not. On a perusal of the final report dated 2012-2025-24, we find this aspect has not been covered. Apart from that, one major loophole we found in the report is that if the case of the investigating agency is that the deceased had dashed against a four-wheeler, which was the cause of the head injuries, ultimately resulting in the death of the deceased, then the investigating agency was bound to investigate that angle of the case as to which was the other offending vehicle. This aspect is the absence of investigation in this direction is a serious flaw, as this is a very vital aspect that has to be looked into, more particularly when the learned writ court directed the investigating agency to do so. Apart from that, the contention of the appellant writ petitioner is that the complaint which was lodged against another doctor who was a pillion rider, and it appears that the police took away the said pillion rider, but the deceased was left lying on the road, and after a couple of hours the ambulance had taken him to the primary health center. It is not clear as to why the pillion rider was taken away by the police as the first instance, and the deceased was left to lie in this place of accident, place where the incident occurred, with bleeding injuries. This aspect has come out in the statement recorded under section 164 CRPC of what is her name?
Suparna Maji. Suparna Maji.
Suprata Maji.
Page 161 onwards, translated.
This aspect also needs to be gone into. The complaint lodged by the appellant's consistent case is that it was not a case of a road traffic accident, and there are photographs to show that the deceased was lying with this helmet on, with the helmet intact, and the question of such injuries could not have occurred except by specifically afflicting the same at the instance of certain third party. All these above facts has convinced us to hold that the investigation done was improper, and several aspects have not been dealt with by the investigating officer, and consequently the final report dated 20/12/2024 filed by the investigating officer, namely the Sub-Inspector of Police, Chandrala Police Station, Hooghly, Rural, deserves to be quashed and accordingly quashed. The entire case file we have placed before the seventh respondent, namely the Additional Director General, Central Investigating Department, West Bengal Police Directorate, Hooghly, Howrah, who shall nominate an efficient investigating officer who shall conduct a thorough investigation and proceed to take action in accordance with law. The entire case file shall be placed before the seventh respondent within 3 days from date, and the nomination of the new investigating officer shall be done within a week, and the investigation shall proceed in accordance with.
I'm deeply obliged, ma'am. Dispose of this. May I submit the affidavit of service?
May I have my lord's kind indulgence to mention a matter, my lord, due to grave urgency, my lord. The matter is appearing as item number 21 today. It was listed, so upon mentioning, my lord, I only beseech my lords to, yes, my lord, so it remains in the daily list tomorrow, preferably at a stage. Deeply obliged, my lord. Deeply obliged.